Welcome, everyone. Thank you for joining us this afternoon for a conversation with Tony Romanucci. Feel free to come on to camera, but please remain muted so that everyone can hear. If you have a question during the program, please put it into private chat to Dean Tanya Luma. I would like, before we begin the program with Tony, to have a moment of silence for George Floyd, Rayshard Brooks, Javier Ambler, Ahmaud Arbery, Breonna Taylor, Eric Garner, Eric Harris, Walter Scott, Laquan McDonald, Tamir Rice, Freddie Gray, Orlando Castillo, Trayvon Martin, Michael Brown, Sandra Bland, and so many more, plus all of their family and loved ones. Thank you. Tony Romanucci is a founding partner in the Chicago-based law firm of Romanucci Blandin LLC, which is a national trial practice committed to fighting for victims, including civil rights actions and victims of police misconduct. The firm has obtained multiple record-breaking verdicts and settlements on behalf of these victims. Tony has been widely recognized for his insight and experience and has been named a top 100 super lawyer for 12 straight years in Illinois, a top 10 leading plaintiff's lawyer in Illinois for 2019 by Leading Lawyers, and has been named a best lawyer 2013 through 2020 by U.S. News and World Report. He appears regularly on local and national television to comment on his own cases and other high-profile legal matters and trends. He also holds a variety of leadership positions within the profession. He's a 1985 John Marshall alum and is very committed to the school's success. Among other things, he served on the John Marshall Board of Trustees and is a current member of the UIC John Marshall Alumni Council. Tony, you're now co-counsel on the George Floyd legal team. I know you want to make a few comments before we get into the question, so I'll turn things over to you.
Thank you very much, Dean Dickerson, and really welcome everybody who is on this call. I really appreciate your enthusiasm for this. And I'm going to go right to the heart of it. You know, what Dean Dickerson did at the start of this call should not be taken lightly. The moment of silence for all those names that she read off should empower each and every single one of you on this call by the time we're done today to want to take action. Every single one of those individuals was a person of color, either unarmed, nonviolent, and was killed unlawfully, unconstitutionally by police officers, mostly white police officers, although there is instances where it's color on color. And that's what we're here to discuss today. Certainly we're here to discuss George Floyd. We're here to discuss even Rayshard Brooks, which is the most recent shooting that we've seen, the killing of a black man who was running away from police officers. But the import, the gravity of what our country is facing is incredible. Just a week ago, I was saying to another group, this country can't sustain another shooting of someone unconstitutionally on camera. And sure enough, within 1 week, it happens. I mean, to me, it's just absolutely unconscionable. It's disgusting, and it requires change. And I'm telling you, as big of a voice as I have on this issue, not only locally, but on a national stage, I can't do it alone. It's going to take everybody in order to change what we really see that needs to be changed. This is a culture. This is something that's been in existence for years and years. And I'm hoping that by the end of this call today, the end of this discussion, that some of you, if not all of you, will feel that passion and that empowerment to do something about it, because you don't have to wait till you're a graduate. You don't have to wait for your JD. You can do it now.
So Tony, you've represented many victims of police violence over the years. People such as Maurice Granton Jr., James Anderson, and Hector Hernandez. And these are not names that we all hear on a regular basis. So can you tell us about those individuals and your work on their behalf?
Sure. So all of those individuals are instances where someone of color was shot in circumstances which we're saying were a violation of someone's constitutional rights. So for those of you who know the type of work that we do, and specifically that I do, my work concentrates mostly on civil rights violations of the Fourth Amendment and 14th Amendment. And if you've gotten through con law, you kind of have an idea what we're talking about here. What I do is represent either estates of people who were killed or people who survived of either excessive force or deadly force. And that's a violation of the Fourth Amendment. And usually along with that is a violation of the 14th Amendment, which is someone's due process rights. So in those instances that Dean Dickerson just read off, and Maurice Granton and James Anderson and Mr. Hernandez, they were all shot and killed by police officers in the exercise under color of law, where we say that their rights were, their constitutional rights were violated. Take, for example, the case of Maurice Granton. Maurice was killed just about a year ago, or was it 2 years ago? That shows you how quickly time goes by. Maurice was a very low-level pot dealer in the south side of Chicago, and he was caught on one of the police pod cameras. They saw him where he may have been passing little baggies of marijuana to other people. So they dispatched. And when a police officer arrived in his squad, police officer got out of the car, chased Maurice. Maurice jumped over a wood fence, and before he was able to reach another side of the fence, there was a noise that was heard by the police that were surrounding the area. That sound was purported to be that of a gunshot, but nobody knew where it came from. Nobody knew who discharged the gun, if it was a gun, but they heard a sound. At the same time that a police officer was chasing Maurice from behind, another one was coming up to him on the side. And Maurice was climbing a fence, and the police officer drew his gun and shot him down while his hands were on the fence while he was climbing it. He was clearly unarmed. He couldn't hold the gun because he had his hands on the fence, and shot him several times. And you know, this is the part that never gets into a trial, because if you've taken evidence, you'll know what's relevant and what's not. But while Maurice was literally squirming on the ground in pain as he was dying, he was shot in his spinal cord, or one of the bullets struck his spinal cord. The police officers were taunting him and the people who were accumulating on the scene, saying, "This is what happens when you don't listen, homies." And that's the difficult part about what we see, is that the taunting, is the harassment that the police officers, even in a moment where they should have been providing medical assistance, right? The general orders of the Chicago Police Department require that whenever there is anybody requiring medical assistance, that they immediately intervene. Clearly, this man was shot several times. He was in distress. Whether or not medical intervention would have saved him is immaterial. Instead of providing medical intervention, they chose to taunt him and the people in the area. With Mr. Anderson and Mr. Hernandez, the issues were a little bit different. Those two cases involve issues that are very near and dear to me. Not that I take any cases above others. I follow the path of justice. But Mr. Hernandez and Mr. Anderson were someone that we called were EDPs, and that's known as an emotionally disturbed person. What's interesting about the definition of EDP, you do not need a psychiatric diagnosis to be an emotionally disturbed person. You don't need to be hospitalized to be an emotionally disturbed person, you need to have either a momentary or permanent emotional disturbance, which could be a clinical diagnosis. And so what happens is that if you look at the statistics overall in this country, somewhere between 1/3 and 40% of people who are shot and killed by police, irrespective of race, are people with emotional disturbances. And why are people with emotional disturbances shot more than others? Well, that's because they can act erratically. They don't always act in conformance with one's expectations of what behavior should be. The issue with EDPs is that most times that calls are made for police assistance, you will hear on the other end of the call, my son, my husband, my brother, my friend needs assistance. He's emotionally incapable, or he's acting crazy, or fill in the blanks as to whatever you want that gives the police notice that they're dealing with somebody who doesn't have his full mental capacity. And don't forget, an emotional disturbance could be a drug-induced issue. It could be an alcohol abuse, either temporary or more chronic. It can be anything. So an emotionally disturbed person is a term of art that's used within the field of police work. And so Mr. Anderson and Mr. Hernandez were both EDPs. Mr. Anderson, for example, was someone that was locked in his bedroom. He was clinically diagnosed with emotional problems for years and years. He was locked in his room with a couple of really old, rusted out box cutters. So if you know what a box cutter is, you know, if you employ the blade, it's got a little bit of a razor blade that comes out maybe about 1/4 to 1/2 inch at the most. And so his mom couldn't get him out of his room. He was in one of those mental states where he locked himself in his room and would not come out. So her defense to getting him out was to call the police because it had happened in the past. And we have that documentation. The police came in the house knowing that he was having an emotional disturbance. He was not coming out of his room. And so what did they do? Make a long story short, because this is a very long, complicated case, they knocked on his door and they invited him to come out. James, come out. But before he came out, they knew that he had box cutters, that they had box cutters in his hands. So now if you know what the law is, if you've read any of the law on qualified immunity, which we'll talk about later, police officers are allowed to defend themselves, to shoot and to use deadly force if they fear that their life is either if they fear great bodily harm or death. So they invite James out of the room knowing that he's holding a box cutter in his hand. So when James came out of his room, sure enough, what do you think was in his hand? Anybody guess a box cutter? Yes. Came out with a box cutter in his hand. So the one officer tactically who was in front of him shot him with a taser. The other officer tactically who was to his side of the bedroom door when he opened, shot him. He dies. 3-week trial. It turns into a hung jury. This was just in September. Turns into a hung jury, not because of anything, because we were going to lose the case or we were going to win the case, but one of the jurors decided to do their own research as to what reasonable was, as to what the definition of reasonable was, because that's part of the jury instruction. And so because the jury did research outside of the boundaries of what the instructions were from the judge, there was a mistrial declared, and so that case will have to be retried. So we can't tell you what the outcome is because the trial was supposed to be a month ago, and because of COVID, there were no trials scheduled, so we're going to have to wait and see what a retrial of the Anderson case will do. But Hernandez was somewhat similar. Hernandez was a case where he was having an emotional episode because he wasn't able to see his daughter. There was a dispute between mother and father who were unmarried over custody of their child. And so what he did was he was holding a knife to his throat, and the police were called on him. And when the police arrived, the knife was still being held to his throat. And as he dropped the knife down to his waist, they unloaded on him and shot him and killed him also. So you see the problems that are systemic in policing. And I just want to get this out there. I am not anti-police. I am not someone who is looking, and we may get into it, time permitting, where we're going to say abolish police departments. We should be a police-free state. That's not the case. I actually can tell you I have the empirical data, especially for the city of Chicago, as to how many of our police officers should not be police officers. So I can tell you within a very, very great degree of certainty how many police officers in Chicago should remain as police officers as opposed to how many should not, because we have taken that issue to trial on a Monell claim, on a custom pattern and practice claim, to prove that the city has deficient policies. And part of the testimony that came out in the plaintiff's case was what percentage of police officers are considered the bad apples, ones who are repeat offenders, who have continuous complaints against them, or have so many complaints against them from citizens for violence, that those are the ones that should be removed, because those are the ones that have the propensity to shoot and kill before somebody uses de-escalation tactics, as opposed to going right to deadly force. And that's the point for emotionally disturbed people. You really need to employ very good tactical principles of de-escalation as opposed to escalation. And we can talk about that continuum of force of escalation versus de-escalation, which is very interesting in and of itself. At least I find it interesting.
Tony, I'm curious, do you recall what that percentage is? I know probably not in front of you.
Oh, yes, I do. That percentage is between 3 and 5%. So on the low end, depending on where you cut off, where you want to cut off how many complaints a police officer has against them, the low end would be 5%. And although the number 3 is lower, it's the higher end, is 3%. So between 3 and 5% of police officers who are currently on the force in Chicago account for, if I remember, it's about 80% of the what are called complaint registers against them. CRs is what they are. Those are the complaints that citizens file against them for abuse. So if you encounter one of those police officers, if you're a person, if you're a black man at the wrong place, at the wrong time, innocent, not committing a crime, you have a very, very high chance of having force used against you, unnecessary force used against you, if you encounter one of those police officers. Say your prayers if you find one of those police officers, because you may have not only unreasonable excessive force, you may have deadly force used against you.
Tony, early in your career, you were an attorney in the public defender's office. Can you talk to us about that period of your practice and how you saw people of color treated and perceived? Yes,
that was a critical moment in time for me. Actually, the exact moment that you're all in right now. I had finished my second year of law school, and I got an opportunity to be a 7-Eleven in the public defender's office. And my assignment was really critical at that time. I didn't understand the importance, how that my first assignment would be in the PD's office. I was either going to be assigned to the appellate division, writing briefs. Thank God they didn't put me there. That would have been a mistake. But they instead chose to put me in the trial division. So at that time, I went to 11th and State Street, where there used to be, used to be Chicago Police Department headquarters. And on the 8th, 9th, 10th, and 11th floors of that building, there were courtrooms. It was, if I recall them correctly, it was auto theft court, it was gun court, it was retail theft, and I forgot what the name of the other courtroom was because I had very little time in there. But I did most of my work in gun court, which was at that time on the 9th floor. And that's where I started learning about what Chicago police officers do. And again, I'm going to make my comment that I'm not anti-police because it's going to sound like I am. But this is what police officers did and still do, because I've been watching this narrative now for literally decades, and the narrative doesn't change. And here's the narrative that I learned. At that time, the police reports would be on paper, right? They wouldn't be electronic. So sometimes they would handwrite them, sometimes they would actually type them in multiple carbon copies. But the narrative never changed. And the narrative would be as such. Police officer or arresting officer would be AO or RO. AO or RO visualized a bulge in pocket of suspect walking down the street, protective pat down, revealed weapon in waistband. Okay? Or the other narrative would be during routine traffic stop, RO observed the butt of a gun sticking out from underneath the front seat, from underneath the driver's seat. Okay? So what's relevant about those two narratives? Well, if you remember Terry versus Ohio, you know that an officer has the ability to perform a protective pat down if he has a reasonable articulable suspicion that either a crime has been committed or one will be committed. The other exception is plain view, right? So those narratives were taught. Those weren't learned narratives. And so, of course, there's the one side would say, well, it helps get guns off the street. Okay, maybe that's true. But what does that really do? Over time, over decades and decades, if you are constantly oppressed, if you are constantly abused by a system, you have no trust in that system. So on a daily basis, I would encounter arrestees, 90 to 95% who were African American, who were arrested for supposedly having a weapon in their possession. Now, many times, I got to tell you, and we may talk about Freddy Wilson, there were no weapons that were present. Because back in the mid 1980s, when I was working, as a PD, there were a lot more drop weapons out there. It's a lot harder now because of cameras, right? Because of pods all over the place. And so many of these individuals never had guns, but they were either planted on them, or it was talked about that if they ran away from them, they threw the gun but couldn't recover the gun, but still charged them for UUW, which is unlawful use of weapon. So every morning it was my job to, as I learned on my first day, I would have to stand on one side of the holding cell and interview all of the arrestees overnight and do their bond hearings. And for the first several days that I did this, I realized that I wasn't being effective doing these bond hearings from one side of the cell. And I'm going to say it because this is how they were referred to. They were all referred to as dogs. If you were on the other side of the holding cell, you were a dog. That's what police officers and the deputies in the courtroom referred to the arrestees. You're either a dog or they were dogs. So I fixed the problem for myself because of my own feelings of how I felt about the people, the human beings that I was talking to. And from that moment on, I insisted on being let inside the holding cell, being locked inside with them, and doing my interviews with them together. I was called stupid, idiot, green, whole bunch of different names for wanting to go inside, but I proved my own point. I proved the point to myself, and I proved the point to all of those who were around me that I was equal. We were all equal to each other, and I was one of the dogs. If they were going to call them dogs, then I'm one of them too. And so I did that for the rest of my time in the PD's office whenever I had to interview somebody, unless there was an extraordinary circumstance. I can recall always insisting that I go into the cell. I'm not even sure if it's allowed now, just because there are other issues, safety issues that maybe didn't exist back then. But that's the culture, you see, that isn't George Floyd in 2020 or Laquan McDonald in 2015. It's a culture that existed not in 1983 when I was a 2L, or maybe 1984 when I was a 2L. It's a culture that existed forever, way before any of us could ever remember in how people of color are treated. In Chicago, we have to face facts. It's a very segregated city. It's a tribal city when it comes to neighborhoods. You know, people say, oh, what neighborhood do you live in, right? It's very tribal when it comes to neighborhoods. And if you hear the term West Side or South Side, right away it comes with a connotation. When I tried a case last year, it was a little over a year ago, a police chase case. The city of Chicago filed a motion in limine seeking to bar me from using the term Englewood, because that's where the chase happened. It happened in Englewood. And they didn't want me to use the word Englewood because Englewood right away sets off alarm bells as to what kind of neighborhood we're talking about. So they didn't want me talking about the neighborhood, Englewood. And eventually I agreed to the motion as opposed to disputing it for other reasons. Sometimes there's give and take on motions in limine. But that's the kind of issues that we're dealing with on a daily basis, not only in life, but also at trial.
Tony, the murder of your current client, George Floyd, was captured on multiple videos. So cameras have changed a lot. So can you talk to us about the impact of cameras on the type of work you do on the civil side and on convictions on the criminal side of police officers who are charged? And also tell us, what is it that we're not seeing, even though that there are multiple cameras around these days?
God, I don't even know where to start with that, because, you know, cameras, you know, really have revolutionized, you know, police brutality and police misconduct. And quite frankly, you know, we don't have more of it. We might have less of it because of cell phones. It just happened systemically and institutionally. Just like police officers would eat popcorn in Bobby Rush's office while the city's burning, right? So, I mean, you know, the brutality had been going on for years and years and years, but now cell phones are just bringing it to light now. You know, obviously the first one, which was not on a cell phone, but I think it was actually a video camera, you know, if you know Rodney King, that was really the first example that I can think of where an instance of police brutality was captured on video, which lit a city on fire. I mean, LA lit up, after the police officers and Rodney King were found not guilty, which to this day I'll never understand, but that's a whole nother subject. And then, of course, once, really the iPhone came in play, that's when cameras, on cell phones became more ubiquitous. That's when, we started realizing, oh, is this what's happening? Is this what's going on? And you look at George Floyd. I will tell you that if that 17-year-old brave girl wasn't videotaping or wasn't recording on her cell phone what happened to George Floyd, they would have gotten away with murder. One thing I wanted to tell you, Dean Dickerson, I really appreciate, because I did see the title of what you call this discussion today, the murder of George Floyd. I commend you for calling it what it is. It was, and it is murder, what happened to him. I can't even, maybe I can if I have time. It's all has to do with time, right? Some of the details about what they did to George Floyd. And unfortunately, George isn't the only one who was murdered, because he was. Freddy Wilson was murdered in 2007. None of you know who Freddy Wilson is, because Freddy was stopped because of a traffic violation. His taillight was out on his car. And he went to go reach in his back pocket for his wallet. And he was shot. Actually, I have it in front of me. I'm going to get it. I want to show it to you, because I keep a trial memento generally on my higher profile cases, or ones that are really meaningful to me. And I actually have right here, so I'm going to reach and grab it. Freddy Wilson was shot at 21 times and was struck 18 times because he was black, driving in a Cadillac on West Madison Street, shot by 4 white police officers. Now, guess what? They found a gun on the scene. But and I'll tell you, the city of Chicago started out right away by telling me, we will never pay you $1 on this case. It's great. See you at trial. I don't care. Is that going to scare me? Absolutely not. And I was reminded constantly, we will never pay you money, because the narrative was that he pointed a gun at them, that he reached in his back pocket, took out the gun, crossed over, and pointed the gun out the open door to 4 police officers. I can tell you, Freddy Wilson wasn't suicidal. He was recording music. He had went out for a beer run because he was recording music at his buddy's home recording studio. He was not suicidal. He wanted to get back to recording. So they shot at him, and what they did was, and I can say this with certainty, okay? They planted a gun. They put a gun about 4 feet from his body. So I was relentless. We did the most extensive forensic examination of that scene that the city of Chicago has never seen, because they didn't do any forensics on the case. 0. All they did was they took the shittiest pictures and the worst video that you've ever seen, and that was their discovery that they tendered to us along with their written report. It was gross, the investigation that they conducted. So we did the investigation. We conducted a full subject matter investigation with God only knows how many experts. And you know what? By the end of it, I can tell you, there's no doubt, 100%, that gun was a plant, because they shot at him wrongfully. Freddy was murdered too. And I don't know if you can see this or not, but we had so many great animations and mock-ups, but sometimes simple is great. And you see all these needles. I don't know if you can, if it really comes up on the video. I mean, honestly, have you ever seen a definition of a pincushion before? Look at him. He was shot from 4 different angles because he was asked to retrieve his driver's license. And that's what he was doing. So the Chicago police, they withheld evidence on us. We found the evidence eventually. I mean, it was all the code of silence. It was the protection. But eventually we uncovered it. We uncovered it. And we know who the police officer was who planted the gun. You know, we tried to press for charges, but without any video and without any eyewitnesses, it's really, really hard to do. But in the end, the city lawyers wound up admitting that the gun was a plant. It was a drop. Did I answer your question?
You did.
Well, there was more to it, I think.
There was a little more, but that was so compelling. I assume that you did end up getting a settlement in that case.
Oh, we got a very substantial settlement out of it. We took the case right up to the point of trial, and it would have been, I mean, I can say it would have been a massacre for them. And they knew that they had to settle with us because the narrative would have been so bad for them. But then, of course, you know, you have to weigh the risk benefit of going to trial and, you know, his children that needed the money. And we made the right decision, but it was a substantial amount of money, you know, for what happened at that time. It was, you know, when we did settle, I think it was the highest settlement for a shooting death from the city.
So, Tony, what can you share with us about Mr. Floyd's situation in that case?
A lot. I mean, there's a lot, and here's what I can tell you. You know, I was retained. You know, Ben Crump is the lead counsel in this case, and Ben and I have been friends for years and years, and we've worked on cases together. So, you know, I was you know, really pleased and honored when Ben said that, you know, he wants me to help him on the case because he obviously knows that I'm a litigation specialist. This is what I do day in and day out. I breathe it. If you say go, I know where to go, what to do, how to do it, and get it done efficiently, quickly, and in the best way possible. So Ben is just a tremendous, you know, civil rights, you know, attorney in and of himself. I think I am too, and together we complement each other very well, because most important thing that we started doing early on with George Floyd, you know, was the message. Was what sort of message do we want to deliver? And I'll give you an example of the message that I created, which isn't really anything brilliant, but you have to learn to message in your career, because by messaging, you can argue an entire case around a very simple message. You can build your themes around a simple message. And so what do we see in the video? I can't hear you, but I know you're thinking it in your head. You're saying we see a police officer kneeling on George's neck. And you're right. You're right. But what have you heard me say in my discussion to you in the past, you know, half hour, 40 minutes, however long we've been on this call? I've been talking to you about decades and decades of institutional racism, decades and decades of mistrust of the community between officers and citizens. So my real message was, and if you heard some of my public comments, because anytime I had a chance, and I do have a chance, I've commented and I've messaged like this in this manner, and CNN has done a very good job of carrying that message out. And as a matter of fact, USA Today picked up on the headline, the Chicago Tribune picked up on it. Many outlets are picking up on it. And my message is this: you may see Derek Chauvin kneeling on the neck of George Floyd, but the reality is that this was the entire city of Minneapolis Police Department with its weight on George's neck. Now you think about that message. What does it mean? Hopefully it opens your eyes and broadens your perspective a little bit more. That what we're talking about is a culture. Hopefully you're imaging right now years and years and years of bad policing, of lack of training, of racism, insensitivities, on top of George Floyd. I mean, do you think that Derek Chauvin thought that he was the only one that it was okay to do this? No. There were 3 other officers there who let it go. Each one of them failed to intervene. My other message, somebody asked me publicly, you know, should they have intervened? And I said, well, legally they had a duty to intervene. But I said, aren't they human beings also? Wasn't there a human inside calling them and asking them to stop what he was doing? That's how they're trained. Now, if you want to get specific, they were actually trained, if any of you know what Killology is. It's a method of training. And that training is something that those officers went through, that Chauvin and I believe was it Fong, the police officer who was standing guard. They were actually trained in Killology in the Minneapolis Police Department. The other 2 officers were newbies. They were baby police officers. And people are saying, well, we should excuse them. We should give them a pass. No. If anything, they were newer to the training. They knew that they had a duty to intervene. But they failed to speak up. Neither one of the 2 other officers took their knees off of his back. And you look at what Chauvin did. Initially, early on, they were saying, oh, he was so casual about what he was doing. He even stuck his hand in his pocket. Bullshit. That wasn't a casual hand in his pocket. That was a designed tactical move to exert more pressure, to center pressure further on his neck. You go back, and of course that video is so widely available. Go back and look at it. Go back and look at it again. You'll see that when Chauvin put his hand in his pocket, he was pushing down on his thigh so that when George moved, he could center his knee more squarely on his neck. And that is Killology. That is a culture. That is something that existed for years and years. So what did we do? You know, what I can tell you, what's become public, just so you get a better understanding. You know, George was killed on May 25th, and you know, I was brought into the case within about 24 to 30 hours of his death. And so we set our own wheels in motion right away. And by that time, we already knew that George had undergone an autopsy by the Hennepin County Medical Examiner. But we know that very typically, and of course, George Floyd changed the world, but very typically, sometimes medical examiners work very closely with state's attorneys or district attorneys and police officers, and you see a lot of parallel narrative that goes on in there. And we didn't want the medical examiner to get his narrative out before we got ours out. So we employed immediately 2 independent medical examiners to come into Minneapolis and conduct second autopsy on George Floyd. We had a duo. If you saw them, it was Dr. Michael Baden, who's one of the most probably, you know, TV famous medical examiners in the world, possibly. And also we brought in another medical examiner from the University of Michigan, and they conducted their autopsy alongside each other. We thought it was important to have two there in order to really substantiate and corroborate what we thought the findings would be. And they did. And then we held our press conference on that a week to the day that George was killed. And we invited our two medical examiners to the press conference to give us cause and manner of death before the Hennepin County medical examiner could. And we did that. And we found out what we all know now is that the manner of death was homicide, which means death by the hands of another. And the cause was mechanical asphyxiation, which in simple terms is he was choked, which we started calling it a public lynching, right? Isn't a lynch, remember what a lynch looks like? There's a rope that hangs around someone's neck. That's choking. What Chauvin did to Floyd was choke. And that was a public execution. So we started messaging right away the entire weight of the Minneapolis Police Department on George's neck, publicly executing him. And nobody could take issue with that because it's the truth. That's what happened to him. George had, I'm challenging you to go read the decisions that really define the use of excessive force, the Garner and the Tennessee cases, Connor versus Graham and Garner versus Tennessee. Challenge you to read them, and you'll read about the split-second decisions that police officers have to make when they use force. Well, do you think that there was a split-second decision that was required in this case? Hell no. They had 526 seconds apiece to decide not to kill George Floyd. They had over 2,000 seconds combined amongst those four bozos to figure out that they were killing somebody second by second. A child knows that you don't choke, that if you do choke, you kill. That's why this is murder, folks.
Tony, we've had some questions from the participants, and one is, how do we motivate officers to speak out? As we've seen before, police experience retaliation against them. How do we hold departments who allow retaliation accountable?
That is another side of the coin that needs reform. People, you may think that the police needs to be reformed. Policing needs to be reformed, and that's true. But you can't reform the police without reforming the unions that represent the police. The unions are the ones that really instill this culture of the code of silence. They're the ones who build on this thin blue line that it's us versus them. They're the ones who literally teach that if you rat, your life will be threatened. And we've seen that in Chicago. That has happened. So if you tell on your fellow officer, if you don't have his back or her back, and you don't back them up in the narrative, you will suffer dire consequences. So you must reform the police and you must reform the union. Somebody asked me today, are the mayors of our cities accountable for what's happening in our society today? And to a great extent, mayors are accountable because the mayors are the ones, through their city councils such as ours, they're the ones who negotiate the collective bargaining agreements with those police unions, who when they give in to those police unions for transparency, they don't want to disclose how many complaints police officers have against them. They want to protect the bad apples. They don't want to discipline the officers who commit continued and repeated acts of violence. That's why mayors are accountable. because by letting them have their concessions, what they're really doing is giving them carte blanche to commit acts of violence. Now, you've heard that the Minneapolis police chief has withdrawn his negotiations from the union contract. Okay, great. Now make it right. I don't care that you withdraw. Now make sure that you get the right bargaining agreements in there so that your officers don't go and kill people and then get away with it.
Is there any city in the United States who has it closer to right than others with the unions?
That I know of?
Yeah.
No. That I know of? No. Is it going to happen now? Well, I think it will. You know, you look at Chicago. I think Chicago police officers have been without a contract now. I think it's going to go on 2 years next month. Are you kidding me? They can't negotiate a contract over 2 years? That shows you how polar opposite the rhetoric is on both sides. And if you've seen, you know, the FOP in Chicago just elected a new union president who himself is stripped of his police powers because he's such a bad apple. So they have this extremist right now who is narrating, who is giving the narrative on behalf of the police officers. I don't know what chance we have in Chicago of getting a union contract, which is actually one which is fair. And again, I'm not against police. I'm pro-police. I am against bad cops.
Tony, you used the phrase Killology, which I had not heard before. Is that official training or what? Where does that term come from?
So my understanding is that Killology started back in the days of the Vietnam War. So when it came, you know, back in Vietnam, and even before then, there was much more opportunity for ground engagement between troops. So Killology was formed to engage troops in the art of the kill when you encountered your adversary on the ground, so that you had the upper hand and you would kill. There's no wounding in war. There's no, okay, I'm just going to make sure that you're okay, then I'm going to leave. It was kill. So Killology somehow then got transferred over into police departments. And obviously there's also the big issue of the militarization of the police department. But you look at the history of the Minneapolis Police Department and who their union president is. He is a lieutenant who is currently serving in the Minneapolis Police Department, Bob Kroll. And he was a trainer. He has been a trainer in the Minneapolis Police Department for years and years, and he advocated Killology. You will find that Bob Kroll trained Killology in the Minneapolis Police Department until the current chief banned it, Arredondo banned it within the last 24 months. I can't be specific as to when, but he banned the training of Killology within the last 24 months.
Tony, we're starting to run short on time, so I'm going to throw a bunch of things out there, and I know you won't be able to address them all, but
of course.
Last night on CNN, there was a program called Mayors Who Matter, and the Atlanta mayor said this situation with police and our citizens of color, it's not something you train your way out of. And I know we had someone ask a question about implicit bias, and I want to acknowledge that and thank that person for the question. But what are your thoughts on some of the reforms that have been discussed, such as changes to qualified immunity, banning no-knock warrants, defunding the police, and then we had one through chat about basically requiring police officers to always have their camera on, and if something happens and the camera's not on, it's a presumption against them in anything that happens. So a presumption that they committed murder if someone dies. Are there any thoughts about legislative or court-imposed action and the impact in this area?
Definitely. I mean, all of those issues that you brought up have to be addressed. You know, the qualified immunity has to be addressed because what's defined as a reasonable police officer right now is too broad. I mean, a police officer who engages in an event where excessive or deadly force is used cannot define himself as reasonable. And the interpretation is right now that any police officer can define himself as reasonable. So you wind up not being able to win your cases on qualified immunity. And then those other issues such as no-knock warrants. I mean, there should never be a circumstance where there's a no-knock. I can't imagine waking up with a bunch of people surrounding me with guns pointed and helmets and military gear and not being scared and doing something that might frighten them into then shooting at me. How do you not defend yourself or make yourself, how do you not make a furtive movement in the instance of a no-knock where a police officer isn't going to aim his AR-15 at you and just blow you right in the head? It's going to happen. However, all of those are just temporary, minor solutions because I know we're running short on time. What needs to be done, and this is why it's going to take so much time, and I've been an advocate of this for years and years and years, and I've been writing about it. Number one, you must throw money into depressed and oppressed communities. They have to have development. They have to have the education. They have to have community centers. And number two, you have to build trust in the community. And the only way to build trust in the community is you have to start with kids at a very young age. And that's why it takes years and years. If children grow up with the trust of police officers through community policing, where they live in a neighborhood where they can feel safe, you will then have a seismic change in the way that our country reacts in situations when force is used. Instances of force that are used, some are justified. We see those that aren't justified. But when they are justified, we shouldn't have riots. We shouldn't have burning of cities. We should have a discussion about it as opposed to violence.
Thank you, Tony. I hope that we can have you back in the near future because there's so much more to discuss. Thank you for coming today and being with us. Are there any final pieces? You started off by saying you hope you could inspire some people to go into the type of work you and others do.
Well, I can tell you this, and you know, every single day, if you can tell, I'm in my office. I've been coming into my office since day one of COVID. And that's because this is my happy place. This is what I like to do. I love my job. It's exciting because I know that if I do the right kind of work, I can have a change. I can make some change, whether it's small incremental change or big change. And that's why I never miss a day in the office unless, you know, I happen to take a vacation day or I go away somewhere. But this is what I love to do. And I'm hoping that you find your sweet spot also. Doesn't have to be what I do. Doesn't have to be civil rights or personal injury. But I hope that you find your sweet spot where you feel the same feeling that I have every day when I walk into the office. That's what I challenge you to do, is make sure that you have that, because that's what being an advocate is all about. You know, you're not just a lawyer. You're not just an attorney. You're an advocate. You're somebody that's going to go out there and change the world.
Thank you, Tony. Thank you, everyone, for being with us today. And Tony, we will have you back soon to continue the discussion.
Well,
I'm
looking forward to it. And I thank you all very much. I enjoyed it. And anytime.
Great. Thank you. Good night, everyone.
Bye-bye. Thank you.